Okay. Let's go on the record on cause number DC 1917269, Man v. Brown. Council, make your appearances.
Bob Metz from Mike Winchester's office on behalf of both defendants in the case.
William Himes for plaintiff Gina Mann.
Jessica Foster for non-party AGG Medical Management.
All right, this is kind of an unusual hearing. It's a snapback hearing. So let's, Ms. Foster, I assume you're going to take the lead on this. Is that right?
Well, Your Honor, it's our snapback letter that's the subject of this, but I thought that Mr. Metz might want to because he filed his motion. I wasn't clear on what his motion was requesting, so I think he might want to explain.
Sure, if I may.
Sure.
We received a letter, a snapback letter. This initially started from, it has to do with a DWQ that was sent out on a cost affidavit for a medical provider, Pine Creek Medical. Their billing is $30,000. It was a $30,000 bill. We received the cost affidavit from plaintiff's counsel showing that all the bill was due and owing. Then we sent out a DWQ that came back a while later indicating that the bill was paid in part, adjusted, and nothing was due and owing. So we had two conflicting affidavits for the same medical bill, a significant amount difference to the extent that we would have never gone out and got an expert for a controverting affidavit had the amounts been what we saw in the affidavit, the sworn testimony of the individual on behalf of Pine Creek that signed the second affidavit. And with regard to that, about 2 months later, I think in April, I think the affidavit was prepared in late January or February, I believe. And then in April, we received a snapback letter that they wanted a response file. They basically wanted the sworn, it wasn't just records they wanted back. They wanted the invoices back that they sent. They said there was a mistake. And then they also were asking for the sworn testimony back, the written DWQ answers as well. And so they wanted that back in 14 days. So what we did to keep in line with their request is we feel we have a basis to object to their request for trade secret. And so we filed basically a motion. I believe the court rules allow us to ask for a hearing date to have our objection then presented to the court. However, in the interim, we also sent out some supplemental DWQs to obtain some different information, and those are outstanding right now. That was referred to in my motion.
Let me ask a question here. So did you send the DWQ directly to the factoring company, or did it go to the medical?
We sent it to the defendant. Actually, we sent it to Pine Creek, which is not the factoring company, it's the provider. Okay. So we sent it to Pine Creek, but now the factoring company has come in and is trying to assert this privilege. As to records or actually sworn testimony and a second set of invoices that was provided to me by the provider. And so they're asking for a snapback for those documents. So I want to do some discovery on it to find out what it's about. And actually, there's a third entity that has not been disclosed here. It's not in the response briefs of counsel, but the invoices refer to a third entity other than AGG that actually made a payment to receive the payment on the receivable. So there's another entity that I believe may be involved. And so I have 3 DWQs outstanding now, one to the provider, one to AGG Medical Management, and one to the third party whose name appeared on the invoice. So I'm trying to find out what's going on there. I have some Cypress type with additional questions, DWQs outstanding to ask about that. I'm assuming I'm probably going to get some objections back on it. We're going to probably be back in front of you before that. But I would like some more information. I would probably like to depose the affiant or who gave the sworn testimony, as well as the individual who signed an affidavit in the response brief to find out what's going on.
Ms. Foster?
Well, Your Honor, the confusion comes from, like you said, this was a DWQ that was issued to Pine Creek, which is another third-party medical provider. And AGG did not find out until April 16th that that had happened. And so by April 27th, we sent our letter out because the cost.
How did the factoring company even get this? That's what I don't understand.
I'm not even sure, Your Honor. I'm not even sure how this came across to us. So I think it's probably another third party that was responding and let us know that this had happened. We do have communication with some of those third parties. So I imagine that there was a communication where they let us know, hey, you're mentioned, your receivable is mentioned in this case it's come across our desk. So when that came across, the problem is that the plaintiffs, it looks like, because we don't have any of this information, it wasn't attached to the defendant's motion, but it looks like the cost affidavit showed the correct full amount due and owing of the bill. And then when it looks like Pine Creek has now hired a third party billing custodian called HealthMart Group. And when that custodian responded to some questions about what was due and owing on the account, they accidentally or erroneously or just didn't understand and deducted actually put the amount that the receivables were paid. So the account is still due and owing, but it's due and owing to AGG. And so the amount that was written in the responses and that was included in the attached invoices that were unredacted showed what AGG paid to purchase the right to collect on the account. So the account remains due and owing.
That's irrelevant, I think, the amount AGG paid. So let me make sure I understand how everybody's related. This is so complicated. So Pine Creek is the medical provider. AGG purchased the account receivable from Pine Creek.
Correct.
And then there's this other company that I guess is doing third-party billing for Pine Creek. Is that right?
Actually, Your Honor, the second set of invoices would seem to indicate to me that I'm sorry, I'm not going to say their name, but the third party that's involved may have actually been the one to pay for the receivables as opposed to AGG. It infers that. It talks about it. It mentions wire transfer. So I don't know that AGG, when I received the response brief from Consul, that's the first time that I saw them say that they're the ones that made the payment. I wasn't aware of that. It appeared to me from the invoices that the other entity may have paid for it. And the invoice or the response affidavit that was attached to their response brief is not the individual that made the error. It was another officer of AGG. So I would certainly like to depose the person who supposedly made the error. The information on the affidavit and response is otherwise hearsay as to the explanation of the error that's involved here. But so the three entities, I don't know. I have an affidavit saying AGG paid it. I have an invoice that makes it look like the other entity paid for it.
Why does it matter who paid for it? I mean, why is that even relevant? This is a personal injury case, right? Mr. Himes, am I right about that?
Yes, sir. It's a personal injury case, and one of my client's medical bills was acquired by a factoring company, is the way I look at it. They have the right, and they billed my client for the full amount of the bill. And one of these entities, Pine Creek, I think, has closed its doors, and they have a record company that is providing their affidavits, and they've apparently, as I've learned through this process we're discussing today, erroneously provided the amount that the factoring company purchased their account for, which I would argue has nothing to do with what my client owes.
Right.
But I believe that's the gravamen of the debate here, that Mr. Metz is trying to figure out if there's something going on from the tone of his motion, but I think it was somebody just messed up.
Well, what I have here, Your Honor, is an affidavit saying that a certain dollar amount was paid. And this is a sworn testimony in response to my request saying, here's the amount that was paid and everything else was adjusted down to zero. So I have a figure from in sworn testimony saying that that's the amount that was due and owing. It is significantly less than the first affidavit. What they're saying right now about the excuse and the error and so forth, at this point, that's a factual issue. I've got two separate sworn testimony affidavits. They can say all they want about this other individual, but he's not here to speak, and they've never filed anything from him saying that I made an error. I think I'm entitled to some discovery with regard to this sworn testimony of two different amounts that are due and owing. And it does make a difference to the extent that under the paid incur, I'm only responsible for what was paid and what's due and owing. And that second affidavit is substantially less for what's paid and due and owing as the first one. They're both sworn testimony. So I think I'm entitled to some discovery on that to find out. And the case law that they've cited, which I also cited, is I understand factoring if this under the factoring companies, that if they're saying that their agreement to purchase the receivables reflected that the plaintiff is still owes the entire amount, that's a factual issue too, that I would want to see what the agreement was. What's their agreement with them? And so, and the other issue, quite frankly too, based on the time lag involved here, is I think I'm entitled to some minimal discovery from them as to.
So let me just ask this: what are you asking for today?
I'm asking for just a hearing date so I can have with some discovery time built in. I filed a motion because they gave me a deadline, and I wasn't going to ignore their deadline. So I filed under the rules. I'm entitled to request the court set a hearing date on whether or not they are entitled to this privilege and to claw back these documents. So under that rule, I filed it to comply with their deadline. So I was acting, promptly, and now I'm asking for a hearing date that will build in some time for me to get some minimal discovery down to figure out.
So you're just requesting a hearing date. Are you requesting discovery as well, or just a hearing?
Yes, I have, like I said, I have 3 outstanding DWQs that I'd like to get responses from. And then there's 2 individuals who I think I want to take their depositions at this point. And that's the individual that responded, signed the affidavit in response to the motion, and the individual who supposedly made the error. That's what I want.
Your Honor, then if Mr. Metz is indulged in that endeavor and it comes back that this is a factored bill, would then this whole process be moot?
Ms. Foster?
Yes, Your Honor. The issue right now is that also under the rules, once we notified the parties that there was a trade secret disclosed and we asserted the claim of trade secret, they were required to return that to us, or all we asked is that it be returned and redacted. Whatever was submitted by Pine Creek that we believe was an error that reflects what we believe was our trade secrets. So all we asked was that they return that. So if he's asking for a hearing right now, we have a motion to compel on file as well. We can set those for the same time, but this is a factoring issue. Our bill that the plaintiff owes is the same exact amount that Pine Creek in their first cost affidavit said was due and owing. And that's what remains due and owing to AGG. So we would ask that the parties comply with our request to snap back that information because it does represent trade secrets. As far as going on record and saying that has been purchased by factoring, we have a notice of assignment that we provided to plaintiffs, notifying plaintiff that the assignment had been made to AGG. So that's all that we believe would need to be disclosed. There already are DWQs that we are going to respond to, but we just received those I'm looking at it, May 28th. And so they aren't actually due until a week or week and a half from now. So we're not at the point to be compelling discovery. And we have a motion that if we need to is on file to compel the return of our trade secret information because it is not relevant to this case.
According to your motion that's set today, it says Defendant Dale Brown, DBA Brown Transportation, pray that the court set a hearing date with regard to defendant's motion to deny AGG Medical Management's claim of a trade secret, deny the demand of AGG Medical Management to claw back documents and information, set a hearing on the show cause motion, allow supplemental discovery in AGG's medicals, and for such future requests. So let's kind of hit each of those. I will allow a hearing date. So that is granted. If you guys want to write this down. So you requested me deny the demand of AGG. I'm going to allow them to claw back these documents and information. I don't find any basis for a show cause, so I'm going to deny that, and I'm going to deny any supplemental discovery in this. All right, did I rule on everything?
Can I have just some clarification with regard to the clawback? There were multiple things at issue. One was they were asking for actual documents in the form of the invoices that they produced. But then they also went beyond that, and they were asking for actual sworn testimony.
Yeah, I don't think you can claw back sworn testimony.
That's why I wanted clarified.
Ms. Foster, I've never seen that before. Is there some kind of case law that you have that could say you could claw back sworn testimony?
No, Your Honor, but the responses to the DWQ themselves should not have been, those can be clawed back. And to the extent that the affidavit itself is just proving up those medical records, the records attached to that should not be, that should be protected by the trade secret, the amounts that we just asked them to redact it.
So you're gonna allow you to claw back all the documents. I don't think you can claw back sworn testimony, so that is not going to be clawed back.
May I clarify, are you referring to the affidavit of Miss Massey, the cost affidavit? Okay.
Yes, all that can be clawed back.
No, that she said Massey. Massey's the first affidavit. The
No,
second
no, not the first affidavit. The
second affidavit is the one they want back. And the only thing I wanted to point out with regard to that, it's not even their affidavit. It's Pine Creek's affidavit. And it's actually, and I didn't mention this earlier, but it's actually Pine Creek is the one that produced the documents, not AGG. I'm not even sure they have a right to request a clawback, certainly not on testimony, but even on documents that were produced by Pine Creek, not by them. They didn't make the mistake. They're saying somebody else made a mistake, Pine Creek, and they want to claw back what Pine Creek produced to me. I'm not even sure they can do that.
Did AGG produce this?
No, Your Honor, AGG did not. It's AGG's trade secret that was inadvertently produced by Pine Creek's billing custodian. But the rules do contemplate allowing a non-party whose trade secret was disclosed, or a party whose trade secret was disclosed by a third party, to claw that back. The trade secret protection still applies.
I'll allow that to be clawed back, the documents to be clawed back. The sworn testimony will not be clawed back. All right, anything else, guys?
May I just clarify, the sworn testimony is just the affidavit. I don't believe that it
No, I meant the DWQ testimony.
Oh. The DWQ testimony is not subject to, is not a sworn affidavit. It's the answers within that response. And the affidavit was just proving up the medical records that were, the billing records that were attached.
Ms. Foster, I'm ruling in your favor.
Yeah,
so
I'm sorry, I'm just getting clarity.
Okay. The answer, maybe I make the answers to the DWQ will not be, there were answers to the DWQs, correct?
Yes, that's what contained the numbers that were incorrect.
Okay.
That's the sworn testimony.
I don't know how you claw that back. I just don't know how you claw that back. Is there a way? Does it say in the rule that you can claw back testimony, or can you just claw back documents? I've never seen this exact situation.
I don't think you can claw back sworn testimony.
What rule number is this again? Remind me.
193.3, Your Honor.
193.3.
Oh, yes.
What says a party who produces material or information without intending to waive a claim or privilege does not waive that claim under these rules if within 10 days or shorter time ordered by the court after producing party actually discovers that such production was made, the party amends the response, identifying the material or information produced and stating the privilege asserted. If the producing party thus amends the response to assert a privilege, the request party must promptly return the specified information or material information, any copies pending any ruling by the court denying the privilege.
Judge,
All right,
that
so
actually-
I'm going to allow that everything to be clawed back. You guys can, and then we'll have the actual hearing on this on the privilege issue coming up whenever you want to set it. Rhonda, go ahead and are you on? Rhonda, are you there?
Could I just ask one more question with regard to that? I'm sorry to interrupt, Judge. The what you just read there actually required them, I think, within 10 days of discovering that to amend their response. With regard to, and we're talking about sworn testimony here, they never actually amended their response and filed anything other than a letter requesting clawback. They never amended a response to the specific interrogatories. I would submit that, but and then just for clarification, are you now going to require the DWQ answers to be clawed back as well, pending hearing, or?
I'm going to order those. I think you're entitled to those. I'm going to order those to be if you want those to be clawed back, they do. I agree with Mr. Metz. Those need to be amended.
Your Honor, the confusion is that they're not our responses at all. So that's what we were asking Pine Creek to do, is just amend those responses to reflect what their records actually are, because we think it was an error, and if they amend it, that could solve this problem. But the thing is that clawback rule applies to parties whose information is disclosed by non-parties. So we would have never had the opportunity to amend any responses because they're not our responses. So we sent the clawback letter within 10 days asking the parties Pine Creek who did file that response to amend that response. But none of the parties have complied yet.
Have they complied with that or not?
No, Your Honor.
Well, they haven't amended in 10 days either. So they didn't give me a second set of sworn affidavit in 10 days like they were required to. So.
Well, Your Honor, it's not their privilege.
They've sold the account, Your Honor.
I'm sorry, Mr. Humphrey.
The account was assigned, so I think maybe Pine Creek lost that privilege.
They're the ones that filed the affidavit, so that's what we're here for today. They responded to the affidavit. So
who actually filled out this? Who did the persons who signed the DWQs actually work for?
They, from what I could see and from what they responded to me, apparently he worked for a company called Healthmark, I believe, and he was acting as the agent for Pine Creek and responding to DWQs and things like that, from what I understand. But he's acting as Pine Creek's agent, not anybody else's that I'm aware of. But
that's my understanding too, Your Honor. They're not acting as our agent. We don't know that company. From what we understand, when Pine Creek has sold their business as well, or going through whatever they're going through, they've now got a third party billing custodian responding to discovery for them. And so this is not our response, and I can't speak for
that custodian apparently made a mistake.
That's what it appears. All we know is that the full amount is still due and owing to us. And so reflecting that on the DWQ is those numbers are our trade secret. And so, Your Honor, it is under the rule permissible to allow the clawback of all material and information that we've claimed trade secret privilege over. And on the hearing that Mr. Metz wants to schedule regarding this, we can go into the details of that. But in the meantime, AGG still needs that information to be.
I'm looking for the actual answers. Did you attach the actual answers to the DWQs?
I did not, because it was being claimed as a privilege, Your Honor. I was going to produce that during a hearing for purposes of an in-camera inspection. I didn't want to file anything. They filed a blacked out redacted version of it. So
at this point, I'm not going to claw it back. I do want to be able to see it. So make sure that you send that to my court coordinator for in-camera inspection.
Okay.
I want to see what the answers are exactly. I'm not going to force you to clock back at this point. And when do you want to go ahead and set this for hearing?
I'd like at least 60 days, maybe 90, because I know they're going to come back in within weeks on an objection. We're going to have a hearing on that discovery. And then I want that to take the 2 depositions. So I'm thinking that's.
I'm not allowing any discovery. I've denied the request for discovery. There's not going to be any discovery.
Okay.
So.
Well, I still, I mean, are you denying that the DWQs have already been sent? They're outstanding. So, and those are actually asking for information that's based on that Supreme Court case. In addition to some follow-up questions on this.
I mean, no one's moved to quash that, but I'm not going to allow any discovery to deal with this privilege issue. Is Ms. Foster, are you going to move to quash that, or Mr. Himes?
Yes, Your Honor, we are. There's already an outstanding motion for protective order on file. I didn't want to cram all of that. Counsel said that he needed a little bit more time to respond to that, so I didn't want to set that for hearing today at the same time, and I thought we might get some kind of guidance today. But that's outstanding, and we'll be quashing the other.
I'm not inclined to allow any discovery on this issue, but by the same token, I don't feel like I would be overstepping my bounds if I say I'm going to quash something when there hasn't or grant a motion for protection that's not set for today. I think this is a mistake. You guys should just move on. But that's, if we want to have a big brouhaha about this, that's fine.
When we send you the document for in camera, do you want both the initial affidavit, documents in support, plus the next one that we're talking about here today, plus documents as well, so you can see both? Or
that's fine.
Okay. All right.
Guys, anything else? Oh, when do we want to reset this then? Actually, you know what? I'm just going to reset it. Let's set it.
Your Honor, would this be both the outstanding motion for protective order that AGG
Now we
has?
need the protective order heard sooner.
Yeah.
Because I don't know exactly what he's requesting. I do think, when did you file the protective order?
I filed that on the 2nd, June 2nd. So that was 6 days ago.
So why don't we set that for hearing on June 15th?
Can we do it a little later in the week? But the only reason I asked that, Judge, is my daughter's getting married this weekend, and I'm just not going to.
You have a new message.
Oh,
I'm not going to have any time until next week to start working on something. So
how about June 19th?
That's fine. Thank you.
Ms. Foster, Mr. Himes, does that work for you?
That works.
Yes, sir.
So Rhonda, set that for hearing on June 19th at 9 o'clock. It's a motion for protection that was filed on June 2nd. And then on June 29th, go ahead and set this. What is this called again? What are we calling this motion that you're talking about, Mr.
Motion
Metz?
to deny their request of a claim of a privilege and for clawback.
So just reset this hearing that we had right now to June 29th at 10 o'clock. Does that work for everyone?
That works, Your Honor.
Yes, sir.
Yes.
Okay. All right, guys, anything else?
No, sir. Nothing from the plaintiff.
Nothing from
Nothing, Your
AGG.
All right. And Mr. Himes, when is this case set for trial?
Thought I saw April.
I think it's March of next year.
Yeah.
Have y'all been to mediation on this?
No, Your Honor.
Not yet.
Okay, great. We'll see you guys over the course of the next few weeks. It's too bad this billing records affidavit was so screwed up. All right. Thank you, guys.
I
Thank
think
you,
Your
guys.
Honor.